The Honourable Member for Halifax.
Thank you, Mr. Speaker. I'm pleased today to speak to C-4, which will make some changes, certain changes to the Youth Criminal Justice Act. My colleague from Windsor-Tecumseh spoke about this bill last week, and he noted that as a society we've been struggling since about 1960 with this idea of what to do with young people when they're engaged with the criminal justice system. Do we treat them as youth, which is different than adult criminals? But yes, we should, but at the same time we have to recognize that they're not adults, even though they commit similar offenses to adults, and we've been struggling with this for a few decades. But in 2002, the House of Commons passed Bill C-7, the Youth Criminal Justice Act, and that replaced the old YOA, the Young Offenders Act. And the YCJA, the Youth Criminal Justice Act, it built on the strengths of the YOA, and it introduced significant reforms to address the weaknesses. And the key concept of the YCJA is that it provides a legislative framework for fairer and more effective youth justice, for a more fair and effective youth justice system. When I was a law student at Dalhousie, I did a clinical law semester where I was expected to work with lawyers on youth criminal issues, youth criminal cases. And one of the very first things that we did in our training was we reviewed the preamble and the Declaration of Principle to the YCJA. Our instructors thought that by reviewing the preamble, this was the most important thing that we could do, to always have it in the back of our minds when we were dealing with youth, when we were giving them advice, when we were negotiating with the Crown, and when we were representing them in court. And the preamble contains significant statements from Parliament about the values on which the legislation is based. And it is noteworthy that the YCJA came about after extensive research and consultation. There are 3 key reports, in fact, that were released leading up to the YCJA coming into effect. These statements in the preamble can be used to help interpret the legislation, and I think it's useful for us to review them. They include the following: that society has a responsibility to address the developmental changes and needs of young persons. That communities and families should work in partnership with others to prevent youth crime by addressing its underlying causes, responding to the needs of young persons, and providing guidance and support. That accurate information about youth crime, the youth justice system, and effective measures should be publicly available. That young persons have rights and freedoms, including those set out in the UN Convention on the Rights of the Child. That the youth justice system should take account of the interests of victims and ensure accountability through meaningful consequences and rehabilitation and reintegration. And finally, that the youth justice system should reserve its most serious interventions for the most serious crimes and reduce the over-reliance on incarceration. Now, these points are really important to remember when dealing with youth who are engaged in the criminal justice system, but they're also really important for us to consider any time we try to make changes to the YCJA. And we have changes before us in Bill C-4, changes that really come from a push for amendments, a push for reform after the Nunn Commission of Inquiry, which took place in Nova Scotia. Pretty much every Nova Scotian can tell you the story of Theresa McAvoy and how it resulted in a provincial inquiry led by Justice Merlin Nunn. It was widely reported, and it really struck to the heart of Nova Scotians. After an extensive inquiry upon the death of Theresa McAvoy, Justice Nunn handed down a report in 2006 called "Spiraling Out of Control: Lessons Learned from a Boy in Trouble." And it was about constructive ways to improve the Youth Criminal Justice Act, but also to improve the youth criminal justice system. There were specific recommendations about changing the YCJA. I believe there were 6 recommendations. Justice Nunn, both in the report and in any media interview he did, he would always say that the Act is a good piece of legislation. It's strong and it's workable. And the term he used constantly was that it needed to be tweaked. My colleague from Moncton Dieppe used the word tinker. And Justice Nunn always said, if we're going to make changes, it just needs to be tweaked. Well, Bill C-4 is an attempt at that tweaking. And the NDP will be supporting this bill because there are some good tweaks, there are some good attempts at trying to fix this legislation, which I'll describe in a moment. But we are also very we very much want this bill to get to committee because C-4 does have its weaknesses, and it's important that we make attempts to improve the bill at committee. Now, Justice Nunn points out in his report that for youths, quote, adolescence is a time of testing limits and taking risks, of making mistakes and errors in judgment, of a lack of foresight and planning, and of feelings of invulnerability. These factors do not mean that a youth who commits a criminal offense should be excused or should not suffer consequences. Rather, they are factors to be taken into account when dealing with a youth, end quote. And I do think that the spirit of these words were taken into account when it comes to one provision in Bill C-4, in that it makes certain, absolutely clear, that no youth, no matter what crime they are accused of or convicted of and sentenced for, that no youth will spend time in an adult institution. Now, some provinces have already been following this principle, but it isn't universal across Canada. Sometimes it's because of a province having a particular ideological approach to punishment of youth, but more often it's simply because they don't have the resources or the facilities to incarcerate youth in a contained setting, especially when you consider rural areas of Canada. The government hasn't done anything to assist provinces in actually meeting this goal. And so it's my hope that the witnesses at committee will be able to shed a bit of light on what it is that the federal government must do to ensure that the provinces can meet this requirement. However, there isn't a specific date concerning this provision, so we're not really sure. There's nothing there to instruct us on when it's going to come into effect, and hopefully we can fix this so that we don't have a bill that will actually not take effect. A change to the YCJA about which I am very concerned is the provision to allow courts to lift the ban on any publication of the accused's name. There are good reasons why we have that publication ban, and admittedly I think that this could be a very dangerous change to the YCJA, but I am looking forward to hearing from witnesses to see what experts who study youth justice, to see what they have to say about this provision, and if they think this change is a wise idea. My colleague and the NDP critic for justice, the member from Windsor-Tecumseh, has already pointed out some problem areas where it looks like this government is trying to get in stronger language for general deterrence and denunciation, which we know doesn't work. However, when one looks at the amendments to the Act overall, there are a few places where it seems like they're trying to get this language in through the back door, trying to get general deterrence in through the back door. Now, there are 6 recommendations in the Nunn report that deal directly with changes to the YCJA, and I will tell you that deterrence isn't one of them, and denunciation isn't one of them. So I'm quite concerned about these sections, and once again do look forward to this bill coming to committee so we can talk to youth criminal justice experts to see if this is actually effective, and maybe flesh out exactly what the Conservatives are doing here with this sort of backdoor language. In all, Mr. Speaker, we are cautiously supporting Bill C-4 at second reading so we can get the bill to committee to hear from witnesses about these proposed changes to the YCJA and to make constructive suggestions for improvement. Thank you, Mr. Speaker.
Questions and comments? The Honourable Member for Bonavista, Gander, Grand Falls, Windsor.
Thank you, Mr. Speaker, and I'd like to thank my honourable colleague for his speech, and I share with her views certainly about the cautious optimism about this particular bill as it enters its way through committee. One of the issues she brought up, which is dear to my heart, which is the idea of how we handle rehabilitation for young offenders regarding rural areas and the facilities available and the programs that are available for the rehabilitation process. So I'd like for her to discuss that further because I know she didn't have a lot of time and she has a wealth of experience in this sort of thing. She did mention the rural areas. So I am particularly concerned about the lack of rehabilitation. And depending on where the resources are, certainly where I am in an area that is sparsely populated, it is of major concern. And so I ask her to bring that up and perhaps bring more details to the House. Thank you.
The Honourable Member for Halifax.
Thank you, Mr. Speaker, and I thank the member from Bonavista Grand Falls for his question. I'm not sure about the wealth of knowledge, but it is certainly it's a really serious issue. I can tell you in Nova Scotia that young people, there's really one facility for young people to go to if they do need to spend time in a youth detention facility, and it's pretty much in the center of the province, but it really ends up taking a lot of these young people away from their homes, away from their communities. And in Nova Scotia, we do have a restorative justice program that is contingent. It relies on community to hold young people accountable. It relies on community to be there when the youth is released and to match their progress in community. So that can have a really detrimental effect. And then we do see the situation in other rural areas of Canada where youth can be put into adult facilities, which, Mr. Speaker, is entirely inappropriate. Young people, they are young people, and they need to be treated like young people, not in adult facilities where they will learn how to be better criminals. We need them to be where they will learn how to be better citizens. Thank you.
Questions and comments? The Honourable Member for Edmonton St. Albert.
Thank you, Mr. Speaker, and I certainly like to thank the Honourable Member from Halifax for a very thoughtful presentation this morning. One of her concerns regarding this bill is the situation where the publication ban on the name of the offender might be lifted. And I certainly agree with her that a blanket lifting of publication bans is not appropriate in the circumstances, but I can envision certain circumstances where the name of the young person ought to be released. And I think specifically of a particularly violent offender, perhaps a sexual predator who's about to be released into the community, perhaps attending a high school. And I'm curious to hear her comments as to whether under that situation, whether she believes the public has a right to know about that individual and his or her imminent release into the community.
The Honourable Member for Halifax.
Thank you, Mr. Speaker. I will say honestly that at first blush, this piece in C-4 raises my hackles and makes me very worried. Right now, I don't really see opportunities where this is a good idea. I am open to hearing evidence at committee that maybe in certain cases this is an effective tool. The YCJA is also about protecting communities, so I have room for being convinced. But on its face, it seems very problematic to me, and if it's used ever, it should be used so sparingly that we could hardly even count on one hand how many times it's used. I don't see how this would be in keeping with many other principles of the YCJA, in particular rehabilitation and reintegration into community. But again, I look forward to hearing from the witnesses at committee. Thank you, Mr. Speaker.
Reprise du débat.